A federal court just issued a ruling that restructures how millions of Americans exercise their Second Amendment rights in public, and for most people carrying a firearm for self-defense right now, the legal ground just shifted significantly under their feet. This ruling directly targets the permit systems that have controlled who can legally carry a concealed firearm in a significant portion of this country. Whether you currently hold a permit, whether you have been considering applying for one, or whether you live in a state where the permitting process has been a genuine barrier to exercising your constitutional right to self-defense. This ruling changes your situation in ways that most people have not fully understood yet. Here is what makes this ruling different from every other Second Amendment decision that has come through the courts in recent years. The judges did not split on this. The panel did not disagree on the central question. Every judge on the panel agreed on the core ruling, not one dissenting voice. In cases involving constitutional rights, that almost never happens. And when it does, it tells you something very specific. The legal argument on one side was so strong, so grounded in constitutional text and historical precedent, that the court found no meaningful basis to rule the other way. That is not a close call. That is a statement. And yet, this barely made the mainstream news cycle. The outlets that would normally cover a ruling this significant buried it. Some covered it briefly and moved on. Others framed it in a way that missed the actual legal impact entirely. If you are someone who takes your constitutional rights seriously, who wants to understand what the law actually says rather than what cable news wants you to think it says, that is exactly the reason this channel exists, and exactly why the next 15 minutes matter to you. Subscribe to this channel right now and turn on the bell. I am building this into a community of Americans who refuse to have their legal rights explained to them incorrectly. A community of people who understand that the Second Amendment is not a political talking point. It is a written constitutional protection that real courts are ruling on in real time. The decisions those courts make affect your daily life directly. This channel covers those decisions in plain language before the noise and the spin set in. The people subscribed here understand what is happening before it affects them. The people who are not find out after. Subscribe now and let us get into what this ruling actually says, what it means for you, and what you need to do about it. Before I walk you through the details, I want to ask you something real. How many of you have applied for a concealed carry permit and waited months for approval, paid fees, completed training, submitted to background checks for a right the Constitution says you already have? Drop your state in the comments right now. I want to know exactly which states have the most people watching this video today, because where you live determines how this ruling affects you personally. Drop your state below and let us get into it. Here is the constitutional foundation of what just happened and why it matters. The Second Amendment says the right of the people to keep and bear arms shall not be infringed. Not regulated at the government's discretion, not permitted at the county sheriff's pleasure, not allowed after you prove you deserve it. It says it shall not be infringed. The word shall is the most absolute word in legal language. It does not say may not be infringed. It does not say should not be infringed. It says shall not, meaning the prohibition is not subject to exception, discretion, or bureaucratic override. The permit system that has existed in a large portion of this country operates on a fundamentally different assumption. It assumes that your right to carry exists only after the government gives you permission. You apply. You pay fees, you submit to background checks, training requirements, and waiting periods. In some states, you go through an interview with local law enforcement who could simply say no based on their personal judgment about whether you demonstrated sufficient need. You wait. You hope. You carry only when the government has formally agreed that you may. The court that issued this ruling looked at that system and compared it directly to what the Constitution actually says, and to the historical tradition of firearm regulation that existed when the Second Amendment was written, and ratified. Its conclusion was that a system requiring government permission before a citizen can exercise a right that already belongs to them by constitutional text cannot be squared with the Second Amendment. The founders did not write a right that requires government approval before it takes effect. The permission slip requirement is constitutionally invalid. Now, I want to make sure you understand exactly what changed and what did not, because This is where misinformation starts spreading fast and where getting it wrong can cost you seriously. Here is what this ruling does. It removes the government's ability to require you to obtain a permit as a precondition to exercising your constitutional right to carry a firearm for self-defense in public. The burden has shifted. Before this ruling, you had to prove to the government that you deserved to exercise your right. After this ruling, the government has to prove that you specifically should be prohibited from doing so. That is a fundamental inversion of how constitutional rights are supposed to work in this country. It changes everything about how the system functions in practice. Here is what this ruling does not do. It does not eliminate laws about where you can carry a firearm. You still cannot bring a firearm into federal buildings, into schools, into courthouses, into airports, or onto private property where the owner has clearly prohibited it. Those restrictions remain fully in force, and violating them still carries serious criminal consequences that this ruling did absolutely nothing to change. This ruling changes who gets to carry. It does not change where carrying is permitted. Those are two completely different legal questions, and confusing them is one of the most dangerous mistakes a gun owner can make right now. Let me walk you through 3 scenarios that are actually going to play out for real gun owners across this country in the coming months. Think through each of these carefully, because one of them probably describes your situation. Scenario 1. You live in a state that operated what is called a may issue permit system. That means the state gave its officials broad discretion to deny your permit application for almost any reason they judged sufficient. A local sheriff could look at your record, your stated reason for wanting to carry, and decide you did not demonstrate sufficient personal need. There was no meaningful appeal. The burden was entirely on you to prove you deserved the right. Under the legal shift this ruling creates, that discretionary denial system is no longer constitutionally sound. The right does not depend on a local official's judgment about whether you personally need it. The Constitution already answered that question. Scenario 2. You live in a state with a shall issue system, meaning the state was required to approve your permit if you met a defined set of criteria. Training, background check, fee, waiting period. This system is less obviously unconstitutional than may issue, but it faces serious new legal pressure after this ruling. The question courts will now have to address is whether even a shall issue system's requirements impose an unconstitutional burden on the exercise of a right that is supposed to exist by default. Training for firearm safety is something every responsible gun owner should pursue on their own initiative. But whether the government can legally hold your constitutional right hostage to a bureaucratic process designed to delay and discourage is now an open and actively contested legal question. Scenario 3. You travel between states with a firearm. This is the most practically complex scenario and the one requiring the most caution. Not every state is immediately covered by this ruling. Some states have their own constitutional provisions operating independently of this federal precedent. Others will pass emergency legislation attempting to maintain their permit requirements through state authority. The legal landscape will vary dramatically from state to state, and it will keep changing for months. Before you travel with a firearm across any state line, you need to know the current legal status of carry laws in every state you pass through. Not last year's status, not what someone told you online, the actual current status. Ignorance of a state's gun laws is not a legal defense, and this ruling does not make it one. Here is a question I want you to answer in the comments, and I want a real answer, not a one-word response. Which of those 3 scenarios describes where you are right now, and what is the biggest question you have about how this ruling affects your specific situation? Tell me your state, tell me your scenario, and tell me what you need to know, because the comments on this video are going to tell me exactly what the next video needs to cover. Here is what is going to happen next, and you need to understand the full picture because the fight is far from over. The states that operated under restrictive permitting systems are not going to accept this quietly. Some will immediately move to comply. Others will pursue emergency appeals, attempting to get the ruling stayed while the case works through a higher court. A third group, and this is the one to watch, will draft new legislation using different language, calling it something other than a permit system, designed to accomplish the same restrictive result through a different legal mechanism. Courts are already watching for exactly this, and challenges to those replacement systems will be filed within months of their passage. Federal agencies that relied on state permit systems as part of their tracking infrastructure are also going to have to adapt. The entire operational structure of how the federal government monitored legal carriers was built around the assumption that state permit records would exist, be maintained, and be accessible. When states stop issuing permits, or when permit systems collapse, a critical layer of that infrastructure goes with it. The legal and operational questions that creates are going to take years to fully resolve, and they are going to generate more court cases, more rulings, and more changes that affect every gun owner in this country. Now, let me address the myths circulating about this ruling, because several of them are genuinely dangerous to believe and act on. Myth 1, that this means you can now carry a firearm anywhere without any restrictions whatsoever. Absolutely not what happened. The ruling addresses the permit requirement. It does not eliminate laws about specific locations where carrying is prohibited. Federal buildings, schools, airports, courthouses, polling places, and private businesses that clearly prohibit firearms are all still off limits. Carrying into any of those locations still carries serious criminal consequences. This ruling changed the permission system for who can carry. It changed nothing about where carrying is legally allowed. Myth 2, that your existing permit is now worthless and you should stop carrying it. This advice is premature and potentially dangerous. Your permit may still provide legal protection in states not immediately affected by this ruling. It may still provide practical benefit in interactions with law enforcement who are not yet familiar with the shifting legal landscape. Do not discard your permit. Understand when it still applies and use it accordingly. Myth 3, that this ruling applies to all 50 states immediately. It does not. The direct application is limited to states under the jurisdiction of the court that issued it. Other states are affected indirectly through the legal precedent it sets and through the momentum it creates, but the direct legal change is not nationwide on day one. Understanding exactly which category your state falls into is essential before you make any decisions based on this ruling. Myth 4, that the fight is over. The legal process here is nowhere near finished. The ruling will be appealed. Emergency stays will be sought. Replacement legislation will be drafted and challenged. What is legally true today may look significantly different in 6 months. The direction of legal travel is clear. The road is not smooth. The people who stay informed and understand each development as it happens will be prepared. The people relying on social media headlines will be blindsided repeatedly. Here's what I want you to take from everything I just covered. 3 things that matter above everything else. First, the burden of proof just shifted. Before this ruling, you had to prove to the government that you deserved to exercise your constitutional right. After this ruling, the government has to prove that you specifically should be prohibited. That inversion changes every interaction with every system that touches your right to carry, and it is one of the most significant practical shifts in Second Amendment rights in generations. Second, the legal environment for Second Amendment challenges has fundamentally changed. Even if this specific ruling gets narrowed on appeal, even if it gets modified or delayed, the direction of the courts is unmistakably clear. The constitutional standard being applied today is more favorable to Second Amendment rights than anything seen in the last half-century. The world we are moving into is genuinely different from the one we came from, and every gun owner needs to understand that. Third, your responsibility just increased significantly. When more people can legally carry in more places, the stakes rise for every person who does. Train properly, know the laws in every state you visit. Understand precisely what you are legally permitted to do and what you are not. The right to carry is not just about you individually, it is about the community around you. When you carry a firearm, you represent every other person who exercises this right. Conduct yourself with the discipline and knowledge that representation demands. Drop a comment telling me specifically what changed in your thinking after watching this video. Not a one-liner, tell me what you believed before this video that you now understand differently. That comment helps me understand what the next video needs to cover. Share this with someone who carries or who has been thinking about it, because the misinformation circulating about this ruling right now is dangerous, and the person you share this with deserves to understand it accurately. subscribe, turn on the bell. We are building something here that the mainstream is not going to build for you. I will see you in the next one.